Put a one in the chat. Put a one in the chat if you can hear me. This is today.
All right, let me turn my attention to Mr. Williams. Good morning, Mr. Williams. Attorney Hoover's present, the DA's office. The state is here being represented by the DA's office. There are two cases, two indictments pending against Mr. Williams. Mr. Williams, Attorney Hoover, on May the 20th of this year, the grand jury indicted Mr. Williams in indictment number 25 SC 003194 with rape, aggravated sexual battery, aggravated sodomy, and trafficking a person for sexual servitude. Attorney Hoover, how do you all plead to that indictment?
Your Honor, Mr. Williams pleads not guilty this morning for 25 SC 003194.
Do you need me to read out all the charges and give them the, you want a formal arraignment, or how do you want?
We will wait for it.
Okay. All right, so Mr. Williams, your lawyer, you know you have a new case, a 25 SC case. We'll give you and your lawyer time to discuss that case, opting into discovery. But I wanted to make sure that we at least handled the arraignment portion and that you knew that you have a second case pending against you at this point in time. All right, so now let's turn to the case that's been here, 24 SC 001723. We had Mr. Attorney Hoover filed a motion to suppress. We had the hearing. There was a supplemental briefing filed by the defense in January of 2025, laying out what all the defense believes should be suppressed based on the hearing. And then in April of 2025, the state filed supplemental exhibits to the hearing, to the motion to suppress. I understand, Mr. Attorney Hoover, you object. You have objected and you still object to the court continuing or reopening the evidence portion of the motion to suppress here. Is that correct?
Yes, Your Honor. Yes, Your Honor, that is correct.
Okay. All right. I know that the defense objects, but over their objection, I will reopen the evidence portion of the hearing and allow the state to present further evidence. 8A.
Judge, would you like us just to jump right into it?
I believe I understand the issue because I've read through your motion. You're saying that Mr. Williams lacks standing to even challenge the search of the vehicle. And if he lacks standing, then we don't even get into his right to be free from search and seizure.
That's correct.
Okay. And Mr. Hoover, is there anything you would like to add other than your objection?
Just the objection, we'd like to also go through sequestration.
Okay. All right. If there are any witnesses, please step out. All right, Attorney 8A Wooten. 8A Wooten.
Judge, the state calls Shirley Strawberry.
Dum da dum dum.
You swear upon that the testimony shall be to the court the truth, the whole truth, and nothing but the truth, so help you God. I get you to state your name and spell it for the record.
Shirley Strawberry, SHIRLEY,
This is from today. This is from today.
Good morning, Ms. Strawberry. Good morning. I'm gonna start out with some introductory questions for you, and then we'll jump into some of the substance. Okay. So, are you familiar with Ernest Williams?
yes, I am.
How are you?
Well, a few years ago, I was married to him.
When approximately, or if you know the date, did you marry Ernest Williams?
January 9th, 2015.
And on January 9th, 2015, did you have any reason to know that Mr. Williams was married to anyone else at that time?
I did not.
And have you since learned that he was married to someone else at that time?
Yes.
In fact, you know that he was married to more than one person at the time that you married him.
I know now. I didn't know then.
And are you still married to Mr. Williams?
No.
Can you explain to the court what happened? And I'm just talking strictly to the marriage, the divorce, the grounds for the divorce, and when that was made.
I divorced him last year, August of 2024.
Was one of the grounds for that divorce these other marriages that were still object to the leading testimony nature of this question?
All right, I'll sustain it.
Can you explain what the grounds for the divorce was?
Yes, because we weren't legally married, as I understood it.
Your Honor, just
Damn.
As a preliminary matter, I want to make sure that there was an agreement that there was that don't apply in a suppression hearing. I've got some case law on that. I'd like permission to just go ahead and use these exhibits, not lay a foundation or anything. I think that's required at this juncture.
Okay, do you have the exhibits? Do you have a copy of them?
Yes, and they've been shown.
Okay. Well, I guess ask your questions, use the exhibits. If there's an objection, then I'll take up the objection.
Just matters for witness.
Yes.
All right, Ms. Strawberry, I'm showing you what's going to mark the state's exhibit. And Judge, may I publish state's exhibit 1 at this point?
And what is it?
This is a motor vehicle credit application and basically sales contract for the F-350 that's at the heart of this issue. So, Your Honor, I understand the rules of evidence don't apply to the suppression motion. However, the witness has to at least acknowledge that she knows what we're talking about before I believe anything should be published to the fact finder which you do in this situation. Okay.
I'll let you ask me some questions.
Judge, I've actually got a case law that says that's not the case, that foundation is not required, authentication is not required. I can present that. The reason why I'm doing this is because she's actually not familiar with it. it was done without her knowledge. So that's the point of showing her the exhibit, to walk through and have her explain that she did not see this until she came to court, or until we discussed in anticipation of court today. But she can't authenticate the document, and that's kind of the point of the whole thing. And I can provide the case law on that if the court would like.
Right. Well, and I don't know that there's a need to publish it, but I'll allow you to ask her questions about the state's exhibit one. If she has a copy, then I'll let you ask her questions, but I don't know if there's a need to publish it in open court at this point.
My concern is just that the court is not able to see it.
I have your motion.
Okay.
That you attached exhibits to.
Okay.
So I think I'm with you.
Okay, that makes sense, Judge. All right, Mr. Mulberry, I want you to take a look at what I've shown you, and it's been marked as exhibit one. Can you read what the top of that, what the title is at the top of that document?
Retail motor vehicle credit application.
And when did you first become aware of this document?
Aware of the document?
Yes.
Right now, since you just gave it to me.
And did you at any point, and we'll get into specifics, but did you at any point give anyone permission to purchase ever a Ford F-350 vehicle in your name using your information?
No.
And so the document that you have in front of you, exhibit one.
Okay, he better take a plea deal. Time to take a plea deal.
Credit application applicant.
Yes.
And there's a first box that has a name. You see that?
Yes.
Is that your name in that box?
It is.
And you see next to that, there's a box that has a date of birth. Is that your date of birth?
Yes.
Do you see the social security number?
Yes.
Is that your, I think you just see the last four. Is that the last four?
Yes.
Did you ever give anyone permission to use your name in the purchase of it?
No, I do not.
What about your date of birth?
No.
And what about your social security?
No.
So I'm going to move down a little bit at the bottom of that first box. You see there's a box with a home phone.